So thank you, Anton. Our next speaker, Greg Porter, practices in general civil matters, and he has particular experience and expertise in insurance matters. And so today we've asked Greg to speak on when is enough insurance coverage. Greg is a graduate of University of Washington Law School and is active in various bar associations as well as with a busy practice. So Greg.
Thank you, Mike Longyear. And yes, good morning, everyone. As he mentioned, I'm Greg Porter. I'm a member attorney at Reed Longyear, and I have a bit of a unique expertise for the firm as part of my practice is in personal injury, which is actually how I started my career, and it's now part of my career here. And with Reed Longyear, I do plaintiff's personal injury. So I represent people who've been injured by others, whether negligently or intentionally, and that means I spend a lot of time dealing with insurance. I'm not an insurance salesman. I'm not here to sell insurance, but these are just observations I've had over the course of my career because in my pursuit of getting compensation for injuries, getting justice, it depends a lot on insurance. And so what's available for people to recover really oftentimes boils down to what insurance there is. So in my lifetime of negotiating with insurance adjusters, suing insurance companies for bad faith, or advising clients on how to handle insurance claims, these are some tips and practice points I've found. So first thing first is that, unfortunately, unintentional injury is a quite common occurrence. As in Washington state, unintentional injury is the third highest cause of death, and auto injury is the leading contributor to unintentional deaths overall. So you've got cancer, you've got heart disease, and then you have unintentional death as your leading causes of death. And then if you're looking at the value of insurance claims, so that's either the settlement or the court award after a trial for when people are injured unintentionally, is you see the value of that has increased by 2/3, about 66% in just the last 10 years. So that actually significantly outpaces overall inflation. So the amount of damages that people are settling for and being awarded is increasing drastically. And it's increasing a lot more on the high end. So at this point in time, is your average insurance settlement or award is just over $24,000. And then your average serious injury is approaching $500,000. And so if you think about what an average means, is that's everything from the most insignificant claim imaginable. You know, a plaintiff is in their SUV and they get nudged from behind by a golf cart and the paint isn't even scratched. That type of claim is in the average. And so you think about if it's going up and it's going up fast, that means that the types of injuries we see and the amount of insurance that people need to really get compensation for their injuries is increasing very, very fast. Now, as I mentioned, your average claim just broke $24,000. And that's a bit of a problem because the minimum policy in Washington state is $25,000. So your average claim is about to overtake your typical policy in Washington state, or at least your minimum mandatory policy in Washington state. And then that's someone who actually has insurance at that minimum of $25,000. And almost 1/4 of drivers in Washington state are completely uninsured. Even though state law requires any driver to have insurance, over 20% of drivers are completely uninsured. So you think about how many cases there are where a plaintiff is injured and the defendant has either no insurance or they have this piddly $25,000 limit, which barely covers your average claim and is only 5% of your average serious claim. So we have a very significant problem of un- and underinsured defendant drivers in Washington state. Now, you might say, who cares about insurance? Is you can just collect on a defendant's assets, you can garnish their wages, execute on their home, And technically, those are options under the law if a defendant does not have adequate insurance coverage. But word to the wise is that those remedies are very difficult and often unsatisfactory. Is the state law provides a number of exemptions and exceptions to collections on a plaintiff's judgment. And the most significant is Washington State's homestead exemption. For most people, their largest asset by far is their home. And in Washington State, a defendant can protect the equity in their home from collections under a homestead. And the law says that the exemption amount is either $125,000 or the median sale price of a single family home in your county. And you get the larger of those two numbers. Now, the median sale price for a home is set by the Washington Center for Real Estate Research. They've published their numbers for 2023. And in every single county in the state, the median value blows way past the $125,000 number. The lowest is Lincoln County at about $250,000, and then San Juan Island County is about $1 million. Now, I live and practice in King County, which is the most populous county, and here the value is just under $900,000. So the overall weight of the counties is well over $500,000, oftentimes approaching $1 million. So this is a colossal exemption if a plaintiff is trying to execute on a judgment. And it really means if you're looking at the type of defendant who is uninsured or underinsured, they can usually protect their entire property from collections by invoking the homestead exemption. Now, another option is a plaintiff can seek to garnish the wages of the defendant. But state law also provides a number of exceptions and exemptions to that type of collections. As if a plaintiff serves a writ of garnishment, the defendant can deduct taxes paid for Social Security, any federal income tax, amounts paid to other liens like child support or a labor and industries lien. And then once all those are deducted, a defendant can also set aside a certain amount for disposable income. So the amount the writ gathers is shrunk and shrunk and shrunk by all these exemptions. As personal story, as I've been working on a collections for a judgment against someone working in construction. And a year of collection efforts in the year 2023 yielded about $250 total for the entire year. And then collection efforts have continued into 2024. And so far we've gotten about $43. So that's less than $300 for a year and a half of collection efforts. And a writ of garnishment is only available for the plaintiff who takes their case all the way to court, who gets a judgment, and who prevails in any possible appeals. So that plaintiff is looking at years and years of costs and aggravation and dealing with lawyers and the stress of litigation. And then this is what they get to show for it. Now, I've chosen an extreme example, but it is a real example. And so if it is a worst case scenario, sometimes the worst case happens. So what should someone do? If you're looking at a state where there's a huge number of uninsured or underinsured drivers, and if your other remedies for collection as a plaintiff are dubious at best, likely unsatisfying, is then it's a matter of protecting yourself and protecting your own and family by having your own robust insurance. And so an auto insurance policy is broken down into three main pieces. The first piece is the liability insurance. So this is the insurance held by the person who caused the injury. So if you're the plaintiff, this is not what triggers. This is the defendant's portion of the policy that triggers. Or if by accident you were to cause injury to someone, then you are protected under your liability policy, as this is really the party responsible for pain, but the insurance company will only pay up to their policy limits. Now, the second major piece is what's called personal injury protection, or PIP. And this is part of the policy held by the injured person. And what this portion of the policy does is it pays medical bills upfront without regards to fault. They don't need to wait until a case is resolved. is even before you file a complaint, is PIP is obligated to pay medical bills. And this is extremely valuable, as I can assure you that a healthcare provider like Swedish Medical does not wait for an injured plaintiff to get their award from a jury. They want their medical bills paid now, and they will send it to collections even with a case pending. So having PIP protection so that those bills are resolved without you having to go into debt, without it going into collections while a civil case is pending, is invaluable. And this is a real trap for the unwary, is that in Washington state, insurers must offer you PIP, but you can choose to waive PIP coverage. And so a lot of times it's pitched as this insurance sale, is look at this great low price you can get. All you have to do is check this little box to waive this superfluous coverage. Think twice about that. If you take anything away from my words today, think twice about that, because this is extremely valuable coverage. It will save an injured plaintiff a colossal amount of grief, and it helps them remain financially solvent while the actual case and insurance claims percolate through sometimes long and arduous process. And then the third piece is uninsured or underinsured coverage. And this is another portion of the policy held by the injured person. And in Washington state, this is a mandatory component of any auto insurance policy. An out-of-state driver might not have this, but any Washington state insured driver will have this. And the way this works is that if the defendant is totally uninsured, or if they have that minuscule $25,000 policy, or even a larger policy, but it's a very serious claim that the liability coverage is insufficient for, then the injured person's own insurance steps in and covers up to their policy limits. And this can sometimes be a painful process because your own insurance steps into the shoes of the defendant, so they will defend against claims as if they were the defendant, but at least there's coverage available. So you're not dealing with a deficit. But wait, there's other types of insurance that are also available. And one that really intrigues me is umbrella insurance. And so oftentimes this is offered as a global policy. So it's umbrella to homeowners, it's umbrella to liability, to auto, to UIM, just provides general coverage. And this is your third layer. So if you imagine a very serious injury, say you're that typical $500,000 serious claim, defendant has a minimum policy $25,000, so that gets wiped out immediately. And then the plaintiff has a UIM policy, but it's also insufficient. Maybe it's 50,000, 100,000. So then that gets spent in full, and you still have barely covered the true value of the claim. If that plaintiff has an umbrella policy, then that can step in and fill out the rest until there's been full compensation for the injuries. And umbrella can be quite nice because the value of the policy versus the price of the policy is you get really robust coverage at an affordable rate. Because again, they're the third layer. So they would only have to pay anything if the first two layers are totally exhausted. So it's often a good bargain to get an umbrella policy. And then there's other types of health insurance that have nothing to do with cars necessarily, but it may also be available for serious injuries. And these sort of function equivalently to the PIP in an auto policy, where they will pay medical bills up front, but all these types of insurance have what's called a subrogated interest. So at the end of the day, even if they pay bills up front, they get paid back from the ultimate settlement or award. And so it's really important that your counsel and you be savvy to make sure that those subrogated interests are protected in a total settlement, because especially entities like Medicare and Medicaid, they are relentless at making sure that they get their liens paid back. And so my advice would be it's better to have claims processed through a UIM and umbrella policy than worrying about protecting Medicare's subrogated interest. Sometimes it can be helped. Medicare just gets billed by the hospital and there's ways to work around that. But if we're thinking here today about how to be proactive, is the takeaways would be to absolutely opt in to PIP coverage, to make sure that the policy has robust UIM limits. I'd say certainly well above the state minimum, as if you look at your average serious claim, it's 20 times the size of the minimum. So absolutely insufficient. You really want a more robust policy, and then consider umbrella coverage if that's available. Thank you.